What about the legal front?
Well, you know, the legal front is always interesting. We've got no shortage of cases. What do you want to know about the legal front?
Are we winning or losing?
It's mixed. What we found out is that there are courts that refuse to follow the Supreme Court's precedent in this topic. Heller and McDonald have very strong opinions. There's a lot of good material in there for our side. But ultimately, judges that are not impressed by those opinions will not follow them. And judges who do feel themselves constrained by Supreme Court precedent, whether they care for it or not, do follow them. And there's so many cases we can discuss, but I'll just give you two examples of I think the opposite sides of how we're doing. In Illinois, I handled a case called Moore versus Madigan, which is a case in which the Seventh Circuit struck down Illinois' total ban on the carrying of handguns. The opinion was written by Judge Posner. Judge Posner, of course, had criticized Heller in very strong terms. In the Atlantic, is having a nearly endless feud with Justice Scalia on a whole host of topics. He is not someone who's considered a gun nut by any measure, but he understands that Heller is precedent. But
opinion was heavily based on that.
His opinion basically said that the Supreme Court's decided self-defense is part of the Second Amendment. Self-defense is as important inside the home.
But his opinion went further. It basically said the state had to show that there was some danger to people and that they hadn't provided any evidence of that. And when he reviewed the literature, he couldn't find even the strongest critics. He basically just concentrated on the empirical work by the strongest critics of concealed carry. And he said he couldn't find anything that basically showed that there was a danger. And they said that was what they had to show in order to meet the balancing test that was there.
But in any event, I wouldn't say that's an empirically based opinion. In fact, to the extent that there is some nod to balancing tests, it's not typically what we go for. We like to argue that the Constitution provides us within our rights, and empirical arguments are extremely useful, especially for amici to make. But at the end of the day, we try to argue this as a matter of law.